All right, let's go ahead and get started. I appreciate y'all participating in our online training session. I'm excited. We have new software. It looks like we're actually going to be able to use this pretty easily and offer these more frequently. This training is specifically designed for cities that have administrative boards. And those, we're going to go over which types of boards have hearings and what due process is, and a lot of that information. So hopefully it'll still be a valuable resource, even if you're not code enforcement. You'll see that a lot of these slides are tailored to code enforcement. That has more to do with the depth of information available for code enforcement boards and code enforcement hearings than it does just trying to leave everybody else out. So we'll go ahead and get started. The Code Enforcement Board. A Code Enforcement Board is an administrative body established and empowered by city ordinance. So what does this mean? An administrative body is simply an extension of the executive branch. What I mean by that is it's not a judicial body. It's not a court of law. It's an administrative body that can issue orders and kind of hear cases regarding city ordinances or city violations and the like. And we're going to talk a lot more about that. Code enforcement boards and some of the other boards we're going to discuss, they can be multi-jurisdictional, meaning there is, sorry, I just had a question from someone asking about whether there's audio. Okay, and I'm sending you Soraya's email. If any of y'all have any issues with the presentation or anything, please email Soraya and she will help you. It's James Clark.
If other people can hear, just tell them to make sure his speakers are on.
And his audio is not working. So anyway, getting back to it. Code enforcement boards can be multi-jurisdictional, meaning you can have joint code enforcement boards. You can also do this with planning commissions, boards of adjustment, ethics commissions, any of the commissions we're going to talk about pretty much. This requires an interlocal agreement. They can be with 2 cities, 3 cities, or with a county and a city. So the board must contain the board must contain at least 3 members who are appointed by the executive and confirmed by the legislative body. Now, in commission forms of government, that's going to be appointed by the commission, right? In city manager forms of government, they could be appointed by the city manager and confirmed by the legislative body. For joint boards, appointments shall be established by an interlocal agreement, but all participating governments must have representation. And board members have to live in the local government territory initially and throughout their term. Vacancies are filled within 60 days by executive appointment, subject to legislative approval. Joint appointments require an agreement of the executive authorities and approval of legislative bodies. A member can be removed by the appointing authorities for misconduct, deficiency, or willful neglect of duty. We do have some other administrative boards that conduct hearings. We have planning commission, boards of adjustment, ethics commissions, the vacant property review boards, parking citation enforcement boards, and economic improvement management district boards. So if any of y'all are on these other boards, we have some slides that apply to you as well. Code enforcement boards and a lot of other boards may assign hearing officers to conduct hearings in several different ways. The other boards that can assign a hearing officer are planning commissions and boards of adjustment. So code enforcement boards, they can assign hearing officers that will issue a recommended order, and then the code enforcement board, the entire board issues the final order. They can do a hearing officer that would draft a final order and appeal that final order to the code enforcement board. The code enforcement board would then only overturn those decisions for if they were substantially, if there was lack of substantial evidence to support the finding, or a final order with a direct appeal to district court. One of the questions that I'll ask cities frequently is, I still don't know of a city that has a hearing officer who only does a recommended order. In that instance, the code enforcement board essentially has a whole other hearing called de novo review. So it would review everything. And then all appeals to district court are de novo, meaning the whole hearing happens again. So having the hearing officer do a recommended order really means that you're having a bunch of different full-blown hearings. So most cities I've seen, if they have hearing officers, they have a final order that's appealed to the code enforcement board. Planning commissions and boards of adjustments, they assign a hearing examiner or an officer, but these are a little different. So, and I say that because they have to be a member of the commission or the board. We'll talk a little bit more about code enforcement boards. Okay, I have one question here. I'm going to write down your questions, by the way, as we go along, and I will answer them at the end. So, for planning and for the planning commission and boards of adjustments, the hearing examiner, hearing officer has to be a member of the commission or the board. They issue recommended decisions, which is kind of the question I got, and I'll go ahead and go into that now. A recommended decision is essentially a decision where the hearing officer will hear all of the evidence. They will make a decision, right, based upon the facts and the law. So they're going to essentially decide the case. However, the information that they're going to provide at the conclusion is going to be a recommended order. The difference between a recommended order and a final order are primarily how much information the appellate body can review on appeal. What I mean by that is, for a recommended order or a recommended decision, so if a hearing officer is issuing a recommended decision to the planning commission or the board of adjustment, the board of adjustment or the planning commission then reviews everything, okay? And they're going to review all the facts, all the law. They're going to make a separate determination and essentially have, it's called de novo review, which means all of it. So they're going to decide the case. They're going to look at everything the hearing officer decided. Like, the hearing officer may have determined, I believe the, the architect and the engineer more than I believe the applicant, for example. Well, the Board of Adjustments may look at that and say, well, we actually believe the applicant more than we believe these other two, or we believe this evidence more than what the hearing officer thought was relevant, and they can make a totally different decision. In a final decision, the Planning Commission, Board of Adjustment, Code Enforcement Board would have to find that the hearing officer did not have substantial evidence to make the determination. So, for example, in a Code Enforcement Board hearing, if somebody said, say I'm the hearing officer and I say, I believe the homeowner more than I do the code enforcement officer, right? In that instance, the only way the code enforcement board is going to be able to make a different decision is if they can prove that there was not substantial evidence in the record for the hearing officer to make that call. So it's a different level of review with a recommended order versus a final order. And I hope that helps. My mouse is getting away from me. So let's talk about who can be a hearing officer. Code enforcement board member can be a hearing officer in a on a code enforcement hearing. A non-code enforcement board member can also conduct a hearing. This individual cannot hold elected or appointed office or be an employee of the local government within the jurisdiction of the code enforcement board. So what that means is that you can have someone, for example, let's say I'm a code enforcement board and I want to have an independent hearing officer. I could go hire an attorney, some kind of outside counsel, and go ahead and make that person the code enforcement hearing officer. However, I can't make the city attorney the code enforcement hearing officer because they're an employee of the local government within the jurisdiction of the code enforcement board. So, and code enforcement board hearing officers must have a certain level of experience and training. Now, the hearing examiners in planning and zoning or planning commissions and boards of adjustment are not required to have this. However, I still think that basic procedural due process training and, of course, some familiarity with the subject matter is good. So the hearing officer must have experience or training in the code enforcement process and basic procedural due process. So congratulations. Any of y'all who are hearing officers, you're getting your basic due process training today. You're going to want to check your local ordinance to find out how much is needed. There may be additional requirements in the local ordinance. What actions qualify for example, code enforcement training experience, when to complete the basic procedural due process, and how to verify. It's at least annually, and we go from there. So, and I did have a question whether the code enforcement board can hear parking citations or whether the city has to have a separate parking citation board. The code enforcement board can hear a violation of any city ordinance as long as it's civil. And we cover that in some of our code enforcement training. So as long as the parking citations are civil in nature, meaning they only have civil penalties for violations, the code enforcement board can hear them. So now on to basic procedural due process. When we're talking about basic procedural due process, we're talking about everything in the Bill of Rights. Okay, we're talking about the 5th Amendment to the U.S. Constitution and the 14th Amendment to the U.S. Constitution. Nor shall any person be deprived of life, liberty, or property without the due process of law, nor shall any state deprive any person of life, liberty, or property without due process of law. What it means: when the government seeks to deprive a person of life, liberty, or property, procedural due process requires the government to provide a person with notice and opportunity to be heard and to confront witnesses. Over the years, courts have determined that the minimum requirements for basic procedural due process comes down to those 3 things. If a government or boards, commissions, and officers acting on behalf of the government takes an action that could threaten a person's life, liberty, or property, these 3 things have to be provided or it risks a constitutional challenge. What it does not mean: it's important to keep in mind that a code enforcement board or any administrative board within a city is not a court of law, and a hearing officer is not a judge. The countless rules of civil and criminal procedures, everything you've seen on Law and Order, CSI, what have you, they don't apply. It's not that formal. In fact, the very point of these administrative hearings is hopefully to avoid the need to ever get into a courtroom, right? So remember that the penalties that may be imposed have to be civil in nature, they're not criminal, or this administrative board cannot hear them. What that means is we also don't have to go through the rights to a grand jury, protections against self-incrimination, the concerns about double jeopardy. None of those apply. Those all relate to criminal proceedings, and a person is not entitled to any of that when they're in an administrative process. So, how do we start with the code enforcement? We're going to start with issuance of a citation. we have a code enforcement officer. They issue either a notice or we're talking about the actual citation. So it's issued to the violator. It clearly states the violation and the penalty, and it tells them you've got 7 days to appeal. If you don't appeal, it's a final order, right? Then if they don't appeal, if they do appeal, you get your notice of hearing. The notice has to be within 7 days prior to the hearing. It has to tell them where and when it is, and it has to be delivered by service of process the same way everything else is. So what that means is either by registered mail, first class mail, in person, or posting on the property if none of the others worked. And then once the hearing is conducted, the final order goes out. It must be a written final order with findings of fact, conclusions of law. It must include the date issued, and it's delivered usually by U.S. mail. And it must include appellate rights too. Okay, basic due process, notice for parking citation enforcement board. It's a citation on a vehicle. I'm sure we've all had those, which is awesome. It gives you the violation, the penalty, and that you have 7 days to pay it. The notice of hearing, 14-day notice, right, prior to the hearing, tells you where and when, and it's usually delivered by first-class mail. Then the final order, the Parking Citation Enforcement Board has to do a written decision, issued at the hearing, appeal within 7 days to district court. Now, so the basic procedural due process for planning commissions, map amendments, public hearing, it's posted on the property, the affected property within 14 days. Adjoining owners must receive notice 14 days in advance as well. The notice of hearing, it's a notice of a zoning change, proposed classification. You have to tell them what you're proposing to zone it from and to. You give them the time, place, and the date. And then the final order, proposed classification is either appropriate or it's not appropriate. The current classification is, they're sticking with it. And you have to say the reasons for changing. What major changes substantially altered the property, if any? And then boards of adjustment, they have their own procedural due process as well. It's a notice, you have to issue it to a person, right? It gives them the entire action that, or notifies the individual of the actions can be taken that can affect their property and lets them know they have 30 days to appeal. The notice of hearing, they have to give that notice of hearing within a reasonable time. It has to be public and to the appellant. So it has to be posted in a public place, can be posted in the newspaper, but it has to be posted physically in a public place where the hearing is going to occur and 1 week prior to the hearing at least. Then the final order, written findings of fact and conclusions of law. They have to explain that that will be done within 60 days after the hearing, and then delivered, has to be served by first-class mail. Okay, so when we're talking about basic procedural due process, the reason we're talking about this is because, like we said, the Constitution requires it. And you're balancing the risk of depriving persons of private interests affected by a state action or a city action versus the fiscal and administrative burdens on the government that are caused by due process. So that's why the due process for criminal cases are so much more detailed and so much stronger than they are for administrative or civil issues. Because when you're talking about code enforcement, when you're talking about a lot of the civil violations, you're not potentially subjecting someone to jail. You know, you're not depriving them of their person. So, what are the procedural duties assigned to either the hearing officer or to the chairperson of the board? They can administer oaths to witnesses prior to testimony, and I include this information in here. Y'all should all get an email from Soraya, and Bob also asked who Soraya is, and she is one of our administrative specialists here at KLC, who keeps Cassie and I running at full steam. I'm including the basic text of an oath. The oaths do not have to be anything super extreme. Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? That's it. You don't have to do anything else. They can add a "so help you God." You don't have to. It's really kind of dealer's choice there, whatever people are comfortable with. The hearing officer or the board chair can subpoena alleged violators or petitioners or what have you, witnesses and evidence. And subpoenas can be served by any code enforcement officer or citation officer. They can make written findings of fact and conclusions of law as part of a written, recommended, or final order. And what that basically means is, based on this evidence, did the violation occur? Based on this evidence, do we need to do a map amendment? Based upon this evidence, what are we, did they park illegally? Whatever issue is before them, they have to look at the evidence and say, this is why I've determined that they have violated this ordinance. As we've stated, the requirements for code enforcement hearing officers are very clear, and I think that they're helpful to other administrative boards as well. Code enforcement hearing officers must know the party's fundamental due process rights, which are basically to be accompanied and advised by counsel at the hearing, to present evidence and witnesses on his or her behalf, examine evidence by the opposing party, confront and cross-examine witnesses. So, as we stated, they don't get to say, I plead the fifth. Okay, if you plead the fifth, that just means that you're not testifying on your own behalf at the hearing you requested. These other processes are really not implicated. Basic procedural due process, as we were talking about. So when we're talking about the right to be accompanied and advised by counsel, both the alleged violator and the city are allowed to have legal counsel, but it's not mandatory. The city attorney can be counsel for the code enforcement board or counsel for the city, but we suggest they not do both. If your city attorney says that they can, more power to them if they're comfortable with it. Our suggestion, though, is to have one for each if you need it. Sometimes the code enforcement board doesn't need counsel, or there are times when the city attorney doesn't have to present the case on behalf of the city, and that's okay. For code enforcement issues, a lot of times the code enforcement officer is just going to present their own case, and there won't really be a cross-examination or a case that's presented by the city attorney. Not that formal. It doesn't have to follow that procedure at all. Any attorney can present and examine witnesses and evidence on the violator's behalf or on the city's behalf, and the attorney can speak on the alleged violator's behalf except when they're giving testimony, obviously. Right to present evidence and witnesses. Evidence can be anything: photographs, videos, documents, any physical proof, receipts, that kind of thing. Witnesses can be neighbors, household residents, police officers, or other city staff, professional inspectors, experts. One thing that I would suggest, and we'll talk about this a little bit more as we go along, is to set limits on the time of presentation and the relevancy of what's presented. What I mean by that is you could end up all day letting someone testify about things that have nothing to do with the matter at hand. You could have a hearing about a code enforcement violation or a parking citation and end up hearing from a myriad of character witnesses who have no actual knowledge of the issue itself. Well, you can, as a hearing officer, allow that in, but you don't have to. When I was a hearing officer, I had one attorney who said that he always knew when he was going to win a hearing because I would start letting them just present any evidence they wanted, say anything, and it drove him nuts because it would drag out the hearing, but he always knew that he was going to win. The reason I did that is because there was no way for them to object on appeal and have my decision overturned, at least based upon whether they were allowed to present adequate evidence. Now, there were other times when I was a little bit more of a stickler about the evidence presented, because even though this is an administrative hearing and it's very informal, you can still restrict any testimony, any evidence to only relevant evidence. And that simply means evidence that tends to prove or disprove a fact that's material to the issue. So if it's a violation of a code, then all you have to do is check to see whether there is evidence tending to prove or disprove that the violation occurred. That's it. So, right to examine evidence and cross-examine the witness of the opposing party. So again, they can also cross-examine any witnesses the opposing party has, right? All right. Subpoenas. Subpoenas are official documents that mean someone has to show up for a hearing or face legal consequences. I'm sure y'all have heard of subpoenas, court orders, and the like. Hearing officers and chairs of the Code Enforcement Board can sign subpoenas. So subpoenas are going to say, you, John Q. citizen, have to show up on August the 21st at 4:30 for a Code Enforcement Board hearing and bring the receipt proving you fixed the roof, something like that. Subpoenas can be for people, documents, or other types of evidence. If possible, we suggest you allow people some reasonable notice before they have to comply with the subpoena. Generally, there are no strict rules to how much advance notice you have to give. However, if you're going to ultimately enforce a subpoena that's been ignored, you want to be able to explain to the court, hey, I gave them 7 days, I gave them 14 days, I gave them 15 days. So that's kind of a suggestion. Now, sometimes you're just not going to have enough notice that somebody needs the documents or the person to come testify. And in that instance, you just do the best you can. I have included a copy of the of the subpoena, and we can send you a better one, by the way, without all the blue lines, because this one, obviously, you can see WordPerfect wasn't happy with me when I drafted this one. So, preparations for hearings. As we've talked about, administrative hearings are not formal. They can be conducted in a city building, in an office or room. They can be recorded on audio or visual. We suggest that you get copies of all evidence. So one of the things that we tell people, if at all possible, get a facility with a copier. When I was a hearing officer for the Cabinet for Health and Family Services, I conducted child abuse and neglect hearings, Medicaid hearings, you name it. I was all over the state, and at that time I had a little mini recorder with me with actual cassette tapes, which that I know that's sad. That just shows you how old I am. But I conducted hearings in tiny little rooms that were the size of a closet all the way to large courtrooms, just because that's what was handy for CHFS. It doesn't matter. The facility, it just doesn't matter. So I always suggest that people tell the parties what to expect at the beginning and introduce yourself. And no, Julie just asked, are the hearings required to be recorded? There's no requirement that hearings be recorded. They're not. You can, but you don't have to. As long as in the findings of fact and the conclusions, you're clear on why you preferred certain evidence over others, that's all that matters. And I suggest explaining to the parties what to expect, introduce yourself, explain the process, including how long it'll take to issue a decision and what the next steps are. So the basic phases of an administrative hearing, you have opening, receiving testimony and evidence, and the closing. I always suggest that hearing officers or board chairs go ahead and take the first part of the administrative hearing as an opportunity to lay the groundwork for how the hearing will proceed. Sorry, I had to pause for a water break. And the reason I suggest doing that is because I dealt with a lot of applicants, a lot of people who were appealing decisions who did not have attorneys, whether it was the child and abuse and neglect hearings or Medicaid hearings or, you know, the public health department hearings where I did milk cases. I really did. It was a lot of fun. Most people were not represented by counsel, so they took a little bit more they needed a little bit more direction on what to do. Everybody's going to be scared when they're in these situations, and they're going to be kind of out of their element. It's an opportunity for the hearing officer or board chair to really establish the ground rules for how the parties are going to interact and the expectations going forward. I found that the more information I gave and the more clear I was with people on the front end as to how I expected people to behave, the better they behaved. So when people get their emotions involved in a lot of these situations where there's an administrative hearing and they want to, you know, verbally attack the other side, if I've explained how this is going to work from the get-go, they know the ground rules, and that kind of relaxes everybody. If the violator is not represented by counsel or the petitioner who have you, the process requires a lot of care, and it's recommended that underrepresented parties be allowed to ask a lot of questions so they understand the process. They're going to have a lot of questions on the front end, and the best thing to do is to be patient. And regardless, it's important to maintain control of the flow of the hearing from the beginning. Unrepresented parties may attempt to attack the citation or any evidence or any violation immediately upon having an opportunity to speak. It's okay to cut them off and ask them to wait their turn. You know, just so that the hearing officer or board chair can try to maintain control of the hearing itself. So if you're recording it, when you start the hearing, you want to start the recording, give the date and time. If you're not recording it, you still kind of want to give the date and time for the record and describe the parties. We're here today in the matter of Elizabethtown versus Smith, and give the citation number or the case number, or however your particular administrative board is documenting the case before you. Explain why you're there. The code enforcement officer accuses Smith of violating the nuisance ordinance blank as indicated on the citation. Explain the alleged violation and how, if true, it would violate the ordinance, and list the section number. Same thing for any of the other administrative boards. If you're at a hearing where a decision is going to be made, explain the process, explain the ordinance reference, and then move forward. Ask the violator or the petitioner or what have you if they're represented by counsel, and then explain the rules of the hearing. It's always good to make sure that people understand, to be clear. State yes or no for the record, and try not to respond by shaking your head or saying mm-hmm or We used to get that a lot. The reason you want to be clear yes, clear no, even if you're not recording it, so there's no question about what the individual is saying and what they're communicating. Advise everybody present to show decorum, to make a clear record. Again, even if it's not recorded, they're not talking over one another, so that everyone can understand what's going on. You can set a time limit on testimony, but I suggest being careful. Each party should be given as much time as necessary to explain their position, and especially with someone who's unrepresented by legal counsel, it's tough for them to feel like they're heard. It's difficult for them to get their words straight. So being as patient as you can with them can be helpful. If there are any witnesses, ask each party whether they want to separate witnesses, meaning that anybody who's not testified can kind of sit outside. Some people want that. And finally, explain that the city bears the burden of proof by proving the violation by the preponderance of the evidence. So City's going to have to prove that it's 51% more likely than not that a violation occurred, or that for planning and zoning, that the decision was appropriate, however it's worded. Starting the hearing, explain that the city goes first because they have the burden to prove their case. Now, this isn't going to be true for every single petition for planning and zoning or what have you. Sometimes you're hearing the petition and there's no violation or no position of the government until that hearing is concluded. So that would be a different process. But generally, in any type of administrative hearing where the city or the government has already issued a decision and that is the subject of the hearing, you're going to have the city go first. The alleged violator can then present their case, and each side gets one other chance to counter. If the alleged violator is not represented, ask them if they have any questions. You may have questions of your own. Again, this is an administrative hearing. You can ask questions as a hearing officer. Anything you need that will help you make a decision in the case. Ask each side if they'd like to make an opening statement. Explain if asked that it's simply an explanation of the party's position. If the alleged violator is requesting an opening statement, they give one first, then the city's next. Receiving testimony, each witness must be sworn in by the hearing officer or the board chair. And again, I've given you the oath one more time. Do you swear or affirm testimony you're about to give is the truth, whole truth, and nothing but the truth? Testimony has several parts. And what I mean by this is there's the initial examination. The party who's presenting the witness asks questions, or if it's an unrepresented person, I can sit there and I can just tell you my story. Then there's the cross-examination where the opposing party gets to ask questions designed to counter the initial position or to provide a different view. So if I'm the code enforcement officer, I may sit up there. I'm going to tell the board exactly why I found that there was a violation, why I issued the citation. Then the violator, the alleged violator, is going to be able to ask me questions, which will usually start something like this. Didn't I tell you that I was getting ready to fix that? Honestly, in my experience, that's the kind of question that's first going to come out. But there may be others later. And again, the hearing officer may have questions. Then there's the rebuttal. The party presenting the witness can ask questions about the testimony, and then surrebuttal. The opposing party can ask questions about the testimony provided. Receiving evidence. Each side's allowed to present evidence to prove their position, and it's admitted as exhibits. This is just for the ease of administration and for reference in writing. The city will provide the citation generally as the first exhibit, and it's really a matter of taste whether to label the exhibits numerically or alphabetically. It can be Exhibit 1, it can be Exhibit A. You can even separate the exhibits by party. You can have City Exhibit 1, then applicant or appellant Exhibit 1, and separate them that way. It's really a matter of choice. But the good thing about having exhibits numbered as they're admitted into evidence is that it's for ease of reference later when you're writing your decision. The alleged violator may provide receipts to show that work was performed to fix the violation or other types of hard evidence. They may even try to admit irrelevant evidence and testimony. You guys are gonna like that. So relevant evidence and testimony. What do I mean? Only relevant testimony and evidence can be considered in making decisions as to whether a violation occurred. Relevant testimony and evidence is only that which tends to prove or disprove a fact necessary to decide whether the violation occurred, or in other administrative boards to support a position that's being asked. So if I want to, if I want a conditional use on my property, the only relevant evidence I can provide is why that conditional use is necessary. So the citation's relevant. A note from mama saying that she really did not do it, maybe not so much. But remember, One of the things that'll happen is that sometimes hearing officers will hear a lot of character evidence just so that the individual, the alleged violator, feels like they're being heard. It may or may not happen. It doesn't have to occur. And now for the closer. Okay, this is a little different for me because you guys should be laughing at my bad jokes and I can't hear you. So I'm just kind of this disembodied individual. All right, closing statements. So in closing statements, again, the hearing officer is going to want to explain the final process. How long is it going to take for a decision? What does the decision mean? What impact will a decision have on the alleged violator? How is this going to work out? Right? What are the appeal rights? All of that information can be provided to the violator in this whole process. So, because I haven't had a ton of questions, I've had some. So let's say if when you get to the hearing, the violator has corrected the issue or violation after the citation was issued and they appeal, what impact does that have on an outcome of the hearing? So a lot of times if they have corrected the issue for which the citation was issued, the Code Enforcement Board is going to go ahead and dismiss the citation. And in a lot of instances, I think that's the best outcome because as we know, when it comes to code enforcement, nobody is going to make any money on this. The absolute best result of any kind of code enforcement process is to get compliance. So if they've remedied it, you know, there's no reason that to get upset if the Code Enforcement Board goes ahead and, you know, gets rid of it. Is debating the code itself, not the application of the code, off topic and irrelevant? That's a great question. You are going to have appellants who are going to challenge the law and say, well, that's just not right. That's unconstitutional. You can't tell me what to do with my property. Or in the adverse, or with other, I shouldn't say in the adverse, with other boards say, you can't tell me that I can't do this with my property. You can't tell me that you're going to change this about my property. I have a right. It's mine. Well, there's really nothing that you can do about the code itself. And one of the things that I had done as a hearing officer is I would just tell people, hey, I understand that you're frustrated with this. This is the process we have. So we're going to move forward with this. And if you feel that your constitutional rights are being violated, if you feel that there are issues, then there are processes for you to challenge it, but this isn't the place. Let's see. And then one of the question is, if you received a warning citation, then the second citation is a fine and the Code Enforcement Board dismisses it. Well, they may or may not, you know, actually make them pay the fine. And again, we're really talking about compliance. So if the Code Enforcement Board dismisses the fine, once they've actually remedied that, I would take that as a win because at least they fixed the problem. And then I got the question, how long are cities required to keep recordings of hearings? You know, that would be, I'm going to have to check the Department of Libraries and Archives website for that one. I do not know that off the top of my head, but we have everyone's email addresses and I can look at that and I can send y'all a link. Any type of records retention for cities, that's going to be governed by the Department for Libraries and Archives, and they have a very good records retention schedule, so we can send that out to y'all. And your city clerk will probably know it too, unless you are the city clerk and you were asking me to find it. So, you know, the question about, the next question is, yeah, we want to gain compliance through code enforcement, but what about the precedent that's set? If it's okay, you know, I'm going to issue the warning citation, then I'm going to give you the actual citation, then you're going to fix it, and people are just going to drag it out until they get the final citation. That's true. The precedent set may or may not be great. However, compliance is compliance. And, you know, the Code Enforcement Board can go ahead and say, okay, well, this has been remedied, so we're just going to dismiss the fine. And I don't like it any more than anybody else, but the fine doesn't even pay for your time issuing the citation to begin with. So, you know, it's really a matter of how the city wants to hold it, or how the city wants to handle things. The question, does a historic district hold hearings, or are those just considered meetings? So that's a really good question. I looked at the historic properties district statute, and it looks like they're just considered meetings. There may be a mechanism for appealing something or what have you, but I did not really see that. But Stephanie, I can double check that, because that was just what I found in my research. And then they asked, so what would stop everyone from asking for a board hearing if the board's just going to dismiss them? Nothing. Nothing would stop anybody from doing it, except for a lot of people just don't. I don't know how many hearings y'all are having, but by and large, I have not seen those really occur. I mean, I haven't seen a board really be challenged for just dismissing the citations after there's compliance. Okay, y'all, I'm running out of questions here, and we're going to end up wrapping up early if you don't answer them. Does anybody have any other questions? Okay, well, then the only other thing I have to tell you is come to our conference, City Jazz, Energize Your City. We are going to have a wonderful conference September 24th through the 27th, and that's in Northern Kentucky at the Convention Center. Yes, you will receive, I got a question, will we receive a copy of this PowerPoint? You absolutely will receive a copy of this PowerPoint. So that will be coming out soon. And then the question, can historic district recommendations be appealed? Historic district recommendations, it's my understanding, go to the council or commission. So, uh-oh, I heard a wait. I'm not going anywhere yet. Don't worry, guys. We did not. Okay, so we did not request continuing legal education credit for this particular presentation. And then I had the question, can a code enforcement officer be law enforcement in a separate county from where they are the code enforcement officer? So are you saying that the city is in one county and then the code enforcement officer is law enforcement in another? Yes. Okay. So this would be a question of incompatible offices. And there is there is a lot of debate about this right now. So does the code enforcement officer live in the city where they are a code enforcement officer? They do not. Are they hired by contract, or do you know? So, James, I think you and I are going to need to have a conversation offline, because I want to make sure that I understand what you're talking about. I'm going to give you my phone number anyway. It is 859-977-4212. And James, you're going to have to give me a call. So, and then I was asked, who can you issue the citation to? The violator, the property owner, or both? We get this all the time. So, you can issue it to the violator, but notify the property owner as well. And this usually comes up in obviously a rental property situation. The violator is the one who should fix it. However, notifying the property owner is also important. And the only way to do that, as far as we know, is to look at the PVA. And then another question. Oh. Okay. Do we have any other questions? I know I have one that I'm answering kind of offline. Okay, then I'm just going to talk to Stephanie a little bit. I'm not going to hang up yet, but everyone else, thank you for your time. We finished a little early. So y'all just let me know if you have any other questions. You can email me at mpatterson@klc.org. Thank you.